Greeting to Dr. Sajita. Today, me, Yap Zi Xuan, and my members Diana and Hashma will be discussing the development of the grant of anti-suit injunctions. Anti-suit injunctions are one of the most controversial remedies in private international law. They raise a direct conflict between two important values. First, the need to prevent abusive or oppressive foreign proceeding and the need to respect the jurisdiction of foreign courts. An anti-suit injunction is an order made by one court restraining a party from starting or continuing proceeding in another forum. In legal terms, the order is directed at the party personally, meaning it controls the party's conduct rather than commanding the foreign court itself. However, in practical reality, it affects foreign proceeding because it prevents a litigant from relying on the jurisdiction of another court. This explains why the remedies has always been sensitive in conflict of laws. The issue becomes more difficult in the European Union. The common law tradition sees the anti-suit injunction as a flexible, equitable tool to prevent injustice, especially where foreign proceedings are abusive, oppressive, or brought in breach of an exclusive jurisdiction clause or arbitration agreement. However, EU law developed around a different philosophy. The Brussels regime is based on mutual trust, uniform jurisdictional rules, and the free circulation of judgment between member states. Therefore, the CJUE has generally treated court-ordered anti-suit injunctions as incompatible with the Brussels system. The central argument of this presentation is that the development of anti-suit injunction shows a movement from common law flexibility to EU systematic restraint. Recent EU law has not abolished anti-suit injunction completely, but it has severely restricted their use by member states' courts, especially where the injunction interferes with proceedings in another member state. In this presentation, we will proceed in a logical structure. First, we explain the common law development and purpose of anti-suit injunctions. Second, it explains the EU Brussels regime and the principle of mutual trust. Third, it analyzes the key CJUE cases on Turner and Rovid, Gasset and Misset, West Tankers, Gazprom, and London steamship owners. Fourth, it evaluates whether the CJUE approach is justified. At common law, anti-suit injunction developed as part of equity's power to restrain unconscionable conduct. Historically, English court justified the remedy on the basis that they were not commanding the foreign court, but controlling the conduct of a party who was subject to their jurisdiction. This distinction is important. It allowed English court to say that the remedy did not directly interfere with foreign sovereignty. However, in practice, the foreign proceedings would often be stopped because the party would face contempt consequences if they continued. This is the reason why scholars like Adrian Bridge describe anti-suit injunction as powerful but exceptional remedies in private international law. The common law courts use anti-suit injunction mainly in three types of cases. First, where foreign proceedings were abusive or oppressive. Second, where foreign litigation was brought in breach of an exclusive jurisdiction clause. Third, where proceedings were brought in breach of an arbitration agreement. In each situation, the court's concern was to prevent a party from gaining an unfair tactical advantage. For example, if parties agreed that dispute must be resolved in England, but one party deliberately sued in another country to delay or pressure the other party, the English court could restrain that conduct. This shows that the common law approach was strongly connected to fairness, contractual certainty, and party autonomy. A key common law case is the Angelic Grace. In that case, the English Court of Appeal adopted a strong pro-arbitration approach. It held that where parties had agreed to arbitrate, an anti-suit injunction should normally be granted to restrain foreign proceeding brought in breach of that arbitration agreement, unless there was strong reason not to grant it. The significance of the Angelic Grace case is that it treated the injunction not merely as a jurisdictional weapon, but as a means of enforcing the party's bargain. This approach was commercially attractive because business parties value certainty. If an arbitration clause can be ignored without immediate consequences, the value of the arbitration agreement is weakened. However, this common law development collided with the EU Brussels regime. The Brussels regime, which began with the Brussels Convention, was later replaced by Regulation 44 of 2001 and is now governed by Regulation 1215 of 2012, also known as the Brussels I recast, created a European system for jurisdiction and recognition of judgment in civil and commercial matters. The purpose of this system is to avoid conflicting decisions and to ensure that judgment can circulate easily between member states. The foundation of the system is mutual trust. Each member state court must trust that other member state court will correctly apply the regulation. This means that one court should not restrain proceeding before another member state court simply because it believes that the other court should not hear the case. This is the real turning point. Under common law, the question is often whether the foreign proceedings are oppressive or abusive. Under EU law, the question becomes whether the injunction undermines the Brussels system. The CJUE's answer has generally been yes. The CJUE's concern is not only with the individual party, but also with the integrity of European judicial area. If one member state court could stop proceeding in another member state, it would seem as if the first court was deciding whether the second court has jurisdiction. This goes against mutual trust, because the idea is that every member state court is equally trusted to determine its own jurisdiction under Brussels regime. The first major CJUE authority is Turner and Rovid. The fact involved proceeding in England and Spain. Mr. Turner had brought proceeding in England, while the defendant also pursued proceeding in Spain. The English court considered the Spanish proceeding to have been brought in bad faith to frustrate the English action. From a common law perspective, this looked like a suitable case for an anti-suit injunction because the foreign proceeding appeared abusive. However, the CJUE held that an injunction restraining proceeding in another contracting state was incompatible with the Brussels Convention. The court reasoned that, even where the foreign proceeding were allegedly brought in bad faith, the foreign court had to be allowed to decide its own jurisdiction. The importance of Turner case is that bad faith was not enough to justify the injunction within the Brussels system. This shows how straight the CJUE's commitment towards mutual trust was. According to Talia Kruger in her article on Turner case, she treated the case as a major development in the European judicial space because it moved the analysis away from domestic equitable discretion and towards systematic cooperation between courts. In other words, the CJUE prioritized the structure of the Brussels regime over the English court's assessment of fairness in the individual case. This is significant because it demonstrates that EU law sees anti-suit injunction as a threat not merely to one foreign court, but to the entire system of mutual recognition.
The next important case is Gesser versus Misat. Although Gesser was not itself an anti-suit injunction case, it is important because it revealed a weakness in the Brussels region. The dispute involved an exclusive jurisdiction agreement, but the CJEU held that where one member state court was first seized, the court chosen by the parties had to wait until the first court decided whether it had jurisdiction. This created the problem known as the Italian torpedo, where a party could deliberately sue first in a slow or unwanted forum to delay proceedings in the chosen court. This is directly connected to anti-suit injunctions because common law lawyers saw injunctions as a practical solution to tactical litigation. However, the CJEU preferred strict application of the lis pendens rule. The Brussels I recast later responded to this problem created by Gesser's case. Article 31 subsection 2 of Regulation 1215 of 2012 gives priority to the court chosen in an exclusive jurisdiction agreement even if that court is seized second. This is an important development because it shows that EU law is not blind to tactical litigation. However, the recast solves the problem through internal jurisdictional rules rather than by allowing one national court to issue an anti-suit injunction against proceedings in another member state. Therefore, the development is not a return to the common law approach, it is a European solution to a European problem. The most controversial CJEU case on arbitration is Alliance SPA versus West Tankers. The dispute arose from a collision involving the vessel's front comber in Italy. The charter party contained a London arbitration clause. Despite this, insurers commenced proceedings in Italy. West Tankers sought an anti-suit injunction from the English courts to restrain the Italian proceedings. The House of Lords was sympathetic because the injunction protected the arbitration agreement. However, the CJEU held that the injunction was incompatible with Regulation 44 of 2001. The court accepted that arbitration itself was excluded from the regulation, but it focused on the Italian court proceedings. Those proceedings concerned civil liability and therefore fell within the regulation. As a result, the Italian court had to be free to decide whether the arbitration agreement affected its jurisdiction. West Tankers is significant because it extended the logic of Turner into the arbitration context. This was controversial because arbitration was expressly excluded from the Brussels regulation. From a common law perspective, the English court was not interfering with Brussels jurisdiction, it was merely supporting arbitration. But the CJEU took a broader view. If the foreign court proceedings came within the regulation, an injunction restraining those proceedings interfered with the court's power to determine its jurisdiction. Academic writers such as Ippolito and Ortolani have criticized the practical effect of West Tankers because it allowed parties to disrupt arbitration by starting court proceedings in another member state. The criticism of West Tankers is strong. It arguably weakened party autonomy because commercial parties who agreed to arbitrate could still be dragged into court proceedings elsewhere. It also created delay and cost because the innocent party had to challenge jurisdiction in the foreign court instead of immediately enforcing the arbitration agreement through an injunction. Pashal-Lidis argues that West Tankers left arbitration agreements protected in the EU framework. However, the case can also be defended. If English courts were allowed to restrain Italian proceedings, then the English court would effectively decide the Italian court's jurisdiction. That would undermine mutual trust. Therefore, West Tankers show the central tension between arbitration and EU judicial integration. The Brussels I recast attempted to address the arbitration problem through Recital 12. Recital 12 confirms that arbitration is excluded from the regulation and that the regulation should not affect the New York Convention. It also states that a ruling by a member state court on the validity of an arbitration agreement is not subject to the regulation's rules on recognition and enforcement. Ippolito and Pachalides have argued that Recital 12 may create room for anti-suit injunctions in support of arbitration. However, Ortolani takes a more cautious view, arguing that Recital 12 does not clearly authorize member state courts to issue anti-suit injunctions. The better view is that Recital 12 limits the effect of West Tankers but does not clearly overrule it. The next major development is Gazprom versus Lithuania. This case concerned an arbitral tribunal that issued an order restraining certain Lithuanian court proceedings. The key distinction from West Tankers was that anti-suit order was not made by a member state court, it was made by an arbitral tribunal. The CJEU held that the Brussels regulation did not prevent a member state court from recognizing and enforcing such an arbitral award because arbitration fell outside the scope of the regulation. Thus, recognition and enforcement were governed by national law and the New York Convention. Gazprom is significant because it limits the reach of West tankers without overturning its core principle. Legal scholar Dr. Jai Sundram asks whether Gazprom brings clarity to anti-suit injunctions under the Brussels regime. However, Gazprom clarifies the position only to a limited extent. The case clarifies that arbitral tribunals are not member state courts and that arbitral anti-suit orders are outside the Brussels regulation. However, it does not say that member state courts can freely issue anti-suit injunctions in support of arbitration. Therefore, Gazprom creates a distinction between court-ordered anti-suit injunctions and arbitral anti-suit orders. This distinction may be criticized as formalistic because both orders may have the same practical effect. Yet for EU law, the source of the order matters because the Brussels regime governs member state courts, not arbitral tribunals.
The most recent important CJEU development is London Steamship Owners Mutual Insurance Association Limited Spain, which arise from the Prestige oil spill. The dispute involved an arbitration agreement in an insurance contract. The insurer obtained an English judgment entered in terms of an arbitral award. While Spain had obtained a Spanish judgment, the question was whether English judgment could prevent the recognition of the Spanish judgment under the Brussels regime. The CJEU held that a judgment entered in the terms of an arbitral award could not automatically block the recognition of the Spanish judgment if it did not comply with the fundamental objectives and requirements of the regulation. The connection between London steamship owners and anti-suit injunctions is indirect but important. The case was not a simple anti-suit injunction case. However, it shows the CJEU's continuing concern that arbitration-related mechanisms should not be used to undermine the Brussels recognition system. According to Hess, the case is significant because it confirms that arbitration is excluded from Brussels one piece, but not in a way that led parties to evade the regulation's core objectives. Therefore, even after Recital 12 and Gazprom case, arbitration does not operate as a complete escape from the principles of mutual trust and judgment circulation. Therefore, the overall CJEU development can be summarized as follows. Turner prohibited intra-EU anti-suit injunctions even where the foreign proceedings were allegedly abusive. Gesser case strengthened the code first seized approach, although this was later modified by Article 31 sub 2 of the Brussels I recast. West tankers extended the anti-injunction approach to arbitration-related court injunctions. Recital 12 tried to protect arbitration but did not clearly restore court-ordered anti-suit injunctions. Gazprom allows arbitral anti-suit orders to remain outside the Brussels regime. Finally, London steamship owners confirmed that arbitration-related judgments cannot be used to defeat the fundamental operation of the Brussels judgment recognition system. From an evaluative perspective, the CJEU approach has strong advantages. First, it protects mutual trust. If courts in one member state could restrain proceedings in another member state, this would create judicial rivalry and uncertainty. Second, it supports the effectiveness of the Brussels system. The regulation depends on each court applying common rules, not on one court supervising another. Third, it promotes the free circulation of judgments, which is central to EU private international law. From this perspective, anti-suit injunctions are problematic because they are unilateral remedies that disrupt a multilateral system. However, the CJEU approach also has serious weaknesses. First, it may underprotect party autonomy. Commercial parties often choose a forum or arbitration seat because they want certainty. If one party can undermine that choice by starting proceedings elsewhere, the agreed dispute resolution mechanism is weakened. Second, the CJEU approach may encourage tactical litigation, especially before the recast corrected the problem of exclusive jurisdiction clauses. Third, the distinction between court injunctions and arbitral anti-suit orders after Gazprom is not fully satisfying. If the practical aim is to stop foreign proceedings, it is difficult to see why the remedy is acceptable from an arbitral tribunal but unacceptable from a national court. Fourth, London steamship owners suggest that arbitration remains vulnerable whenever it overlaps with the EU judgment recognition. In my view, the CJEU's approach is understandable, but it is not perfect. It is understandable because the Brussels regime cannot function if member state courts are allowed to restrain each other's proceedings. Mutual trust requires restraint. However, the CJEU has sometimes placed too much weight on system coherence and too little weight on party autonomy and commercial certainty. A more balanced approach would allow stronger protection for arbitration agreements while still preventing abusive judicial interference. The Brussels I recast partially moves in this direction, especially through Article 31 sub 2 and Recital 12, but uncertainty still remains. In conclusion, the development of anti-suit injunctions shows a major contrast between common law and EU law. In common law, the remedy developed as a flexible, equitable response to abusive litigation and breach of jurisdiction or arbitration agreements. In EU law, the CJEU restricted the remedy because of mutual trust and the need for uniform jurisdictional rules. The key line of authority is clear when Turner case rejected intra-EU anti-suit injunctions. West tankers applied similar reasoning to arbitration-related court injunctions. Gazprom distinguished arbitral anti-suit orders, and London steamship owners confirmed that arbitration-related mechanisms cannot undermine the Brussels system.
Therefore, recent EU law has not destroyed anti-suit injunctions entirely, but it has transformed their role. Within the EU judicial space, court-ordered anti-suit injunctions are largely incompatible with the Brussels regime. Beyond the Brussels regime, especially in arbitration and post-Brexit common law practice, the remedy remains important. This balanced position best reflects the development of the law, the CJEU's case law, and the continuing tension between mutual trust, party autonomy, arbitration, and effective cross-border justice.